So good evening. I am Erica Smith. I work with COSCAT, which manages the rights of people in music. But other than that, I do intellectual property consultancy. I work in copyright, trademarks, geographical indications, and basically the whole spectrum of intellectual property rights, primarily for the cultural and creative industries, but in other industries as well. So over the years, photographers have asked about having some sort of session, and I did one. I checked in 2010, and then Mr. Bradley Benskin reached out. So I thought it would be a good idea. I've split it into two parts, really, so it doesn't become too tedious. And I apologize if it is tedious. I'll do more of a background today. And whilst I will present slides, I would like it to be interactive. And then next week I look more at the online environment. And I've also asked Derek Wilkie, I don't know how many of you know him, but I've asked him to come in and do a little demo of an initiative that he's starting up or has started with the fine artists, the visual artists, for online sales. And I think it could be interesting for photographers who are doing artistic work as well. So he will speak to that and how that whole e-commerce initiative will work. So I will ask that you each introduce yourself very briefly so I can know who's here. And then I will start my presentation, but it is supposed to be interactive. I cannot go later than 8. I don't know if it will take that much time, but I'm hoping that there is enough time to allow for a lot of interaction. So I guess we can start with Bradley, since he's top of my screen, and go from there with the introductions. Thank you. Just tell me if you can hear me well, because I tend to mumble and talk quietly. So sometimes I need a little nudge. So please feel free to let me know. Thanks.
No problem. Good afternoon, everybody. My name is Bradley Benskin. I'm a photographer. I'm a member of the Barbados Photographic Society, as well as a number of other camera groups. I am a registered cultural practitioner with the National Cultural Foundation. And I have also
Bradley, can't hear you. You're not muted.
Is it coming through better now?
Yes.
Okay, right. I don't know which part you didn't get. But let me go again. I am a member of the Barbados Photographic Society, and I am also a registered cultural practitioner with the National Cultural Foundation. And I'm a member of an international group called Guru Shots. And as a result of that, I've exhibited quite a number of places digitally, more or less. I've done a couple of galleries. And I've been doing photography for the better part of almost 30 years. Believe it, started as a kid. So that's basically me in a nutshell.
Thank you. Graham Gittins.
Good evening.
I am a member of the Barbados Photographic Society. I've been more or less into photography for the past, I believe, 4 years or so. That's about it.
Okay, thank you. Audrey Bryan.
Hi, good everybody. Good afternoon, everybody. Some of the faces look familiar. We are all members of the Barbados Photographic Society. I'm not sure what's happening with the camera, but my name is Audrey Bryan, and I am a member, an active member of the Barbados Photographic Society. I am an amateur photographer. I more see it as a hobby, but I've sold a couple of pieces. I'm also a registered member of the NCF as well. I'm an artist. So I have the combination of both photographing my art pieces. And this topic is very relevant to me because I want to take it beyond just being a hobbyist and be able to put my work on the World Wide Web. So I appreciate and thank Bradley for having this forum. And thank you for in advance, Erica, for be willingly to present this to us.
You're welcome. Victor Gittins.
Good evening, all. Yeah, I echo the sentiments expressed by Audrey in terms of thanking you, Erica, for being so kind as to put on this educational session for us. And thanks to Bradley for arranging it. Okay, so I am the president of the Barbados Photographic Society. Not that I am any big shot photographer. I perhaps I'm a bit better at administration, so they chose me for my sins. But yeah, a lot of our members exhibit on our Facebook page. We exhibit in actual gallery exhibitions. And so a lot of us have concerns about copyright and so on. So we will listen very attentively to see what's being, to hear what's being said, and hopefully you have some questions. It's been unfortunate we don't have more members participating at this time. I don't know if it's work issues or what, but certainly we have quite a number of members. So hopefully they will take the opportunity to listen to the, or interact with the recorded session once that's done. Thank you very much.
Okay, thank you too. We have Jerry Gibbons.
Hi, good afternoon all. Hope you're hearing me okay. Yes, I'm just an amateur photographer, do it mainly for hobby. Recently retired, but I've been interested in photography actually from the time I was at school. I was a member of the Convermere School Photographic Club. I remember the days of film and developing film for pictures. Other than that, I just post photos on the Facebook page. I'm looking at probably getting into selling some of them online. So therefore, I'm very interested in this program, and thank you very much, Erica, for taking the time, and Bradley for organizing it. Basically, that's it for me.
All right, you're welcome. Next, we have Kevin.
Hi, good afternoon, everyone. Yeah, Kevin Culpepper, member of the Photographic Society. I was particularly interested in this session because in the past, well, a few years ago, I've seen a few of my pictures, well, two pictures in the print, one in the print media and one on a website. So just interested in how do I go about protecting my property from that.
Okay. Thanks, Kevin. Marco?
Yes, good evening. My name is Mark Wellington. Yeah, I've been doing photography since around 1986, back in what we call the film days. I've done a lot of stuff like graduations, weddings. I've covered a whole set of sports like cycling and road tennis. I have a lot of those on my Facebook page. What bothers me sometimes I see some of my work on posters and I'm still at a loss as to how to approach this type of stuff. So this presentation is very, very important to me from that angle. And that's about it.
Thank you. With Hans? If you're talking, we can't hear you. Okay. We'll come back to you, but now we'll move on to Timothy.
Hi, good evening. My name is Timothy Leach. I have been involved in photography for, I can't put a name or a time on it, but both as a personal hobby and commercially. I've done some stuff with the NCF, done wedding shoots, glamour shots, and stuff like that. I also do, because I'm heavily involved in graphic art and graphic design, I do a lot of my own shots as well for that. So listening to what is happening here to see how best I can also protect myself, because I exhibited locally as well as sold images. So this will be very important for me to know how to operate going forward.
Okay, thank you. With Hans, are you ready? Okay. Levi, I know Levi King. Levi, can you just say a little bit about yourself? All right, I don't think that's working either. So Dr. Mon, would you like to tell us a little bit about yourself?
Okay. I'm a photographer most of my life, and I can't paint or draw, but I have done a lot of photography, and some of it has come out pretty good. But this topic, I need to learn a lot about copyright. Different people say different things, and I don't know what is the correct thing. So I'm hoping to learn something this evening.
Okay, I didn't know you did photography. I know you dance.
Yeah, photography was long before dancing.
Okay.
Yeah.
All right, and then we have Sherlock Lord. I don't know if Sherlock Lord is also with Hans, because with Hans said they're going to re-enter, but Sherlock Lord.
Yes, Sherlock Lord is correct.
We're doing short intro, Sherlock.
Okay.
So it's your turn.
Oh, Sherlock Lord, as you said, I'm a member of the Barbados Photography Society. And I'm here to learn something new.
Okay. All right, we have one person, Michael. So we'll do Michael and then I'll start. So Michael, we're just doing short introductions.
Hi, can you hear me?
Yes.
All right, I was with Hans just now. Yes, Bradley invited me to the meeting. I am a freelance photographer. I like a lot of fashion shoots. I have done captured some images for certain pageants and fashion shows. Done some work with Barbados Today as a result.
Okay. All right. Well, thank you. That was very useful in terms of understanding your backgrounds and what might be of interest. So the online dominates and unauthorized use. So for those who joined me, I am doing online next week. And that's because it's really important to look at some of the basics first, which would apply online or offline, to be honest. So next week we'll go into online primarily. And as I said, I asked Derek Wilkie to speak to you about the e-commerce platform that has been set up primarily for the visual artists, but you know, for artistic photography as well. So I'm going to share my screen. It has to be a little academic, but I don't want to make it too, you know, boring or what have you. So, well, first we'll take a step back. The primary focus for you will be copyright, but I thought I should explain.
One of these medications, right?
Yeah.
So how can you take with it?
Mute yourself. Mute yourself.
Could be error or could not be error. Because my natural
You. Okay. I'm just going to mute everyone first. All right. So as you probably would have heard by now, intellectual property rights are a group of legal rights granted for creations of the mind. And they're property. So just as you would think of other forms of property, the same applies to intangible intellectual property. It's just that it's nothing physical you can feel. So your photography, the photos can be printed and you can have physical copies, yes, but the rights therein, of course, are intangible. It's not the actual copy that is of concern. So like property, like your car, your house, your land, you can sell it, you can license or lease it, you can just give it away. And you can also use it as collateral, a security. And in fact, there is an initiative in the region right now to really develop the use of intellectual property assets as collateral. You do not get intellectual property rights for ideas. So just bear that in mind. So just having an idea is not sufficient. It has to be an expression of the idea. So if you have an idea to take a photo of a lady on a bridge, the reality is anyone, of course, can take a photo of a lady on a bridge, but it is your specific expression, your specific, photo that will be protected. These are exclusive rights. So it means that the owner alone determines how these rights are used or exploited. And I have rights holder in bold, and we'll discuss that because there can be a difference The first owner of copyright, as you will learn, is called an author. So you can be an author where you actually created something, but you're not necessarily the holder of the right. So we'll look at that in detail because it's important, especially for those of you who who do freelance work for the media and commission work like weddings and so on. So the value of intellectual property rights is because of this exclusiveness. Once you own the right, you can use them to block others from entering the market. You can commercialize those rights, of course, but that's why they're valuable, because if you own it, it's yours and yours alone. And we'll talk about what that means in terms of copyright, because the reality is, and I'll briefly introduce some of the other intellectual property rights. And whilst copyright is exclusive, it's still not as strong as some of the other rights. So I'll explain. So this list here shows you some forms of intellectual property rights, or at least the key ones. I assume most of you would have heard of patents or patents. And these rights are granted for technical inventions. So if you created a type of engine or solar energy system or battery, anything technical, once it is new, it has to be completely new. It cannot have been disclosed. And this is why you always tell people when they're involved in inventions not to disclose the inventions, because if you disclose, you will lose your right to obtain the patent, or you could lose that right. But those patents are for technical inventions. They have to solve a technical problem. I just need to say, because I didn't say, I had it on the front slide. Please do not record me or take photos. I will make the recording available online, but I need to control it. So please just respect that and don't record the screens or take photos. I'll make it available. All right, so other than patents, you have another form of intellectual copyright, which are trademarks. And trademarks might be of some interest for you, depending on how you want to develop your business. But a trademark is how you distinguish your business from that of your competitor, or it could be, you can have a service mark as well. So if you don't trade in goods, but you trade in services, then you have a service mark. Let's be clear, a trademark is different from your business name or your domain name. So, one second. So what that means is that your business might be called Baba's Photos, Baba's Photos Inc. That is a name you would have registered with Kaipo as your business name, Baba's Photo Inc. as your registered name. You could then have a trademark, Baba's Photos. Now, that is, it's the same words as the name of the business, but the rights in a trademark will be different from the rights in your business name. The business name just gives you rights to the business name. It has nothing to do with a trademark. And of course, you can have babelsphotos.com, which is a domain name. And a domain name, the words are the same, but the rights are different from those in a trademark. And I need to make that clear because often people say, I have a trademark, but in fact, all they've done is register the business name. Rights are different. Trademarks are registered on a territorial basis, as are patents, as are industrial designs, in fact, as are most intellectual property rights, except copyright. So when you register a trademark or a patent or any of those rights, you have to think about things like which territories am I going to be operating or selling in, and you do the registration on that basis. So you have a trademark Babel's Photos, which you use, say, on merchandise, on posters or whatever. You have to also know that you're registering the trademark by classes. So if you offer different forms of products or services, there's an international classification system, and you have to register according to the class you'll be trading in, etc. I'm not going to go too deep into trademarks unless you are really interested in learning a bit more. I can do that a little next week. Why would you be interested? Those of you who are keen on doing merchandising, for example, then, you know, or specific types of products making use of your photos, you may want to look at having a trademark. You have another right called the industrial design. And this is a right that concerns how products look. So it's really, these rights are really, really important in industries like the automobile industry, the mobile phone industry, the fashion industry. Every product has a, like this has a design. Everything has a design. And when that design is novel, is new, companies will register the design to prevent others from copying it and to help with their branding. So this is a, I think they call it the magic mouse. And this 99% sure is a registered design. It has a specific aesthetic, and Apple would register it along with the trademark. So on this, you'll see, maybe you can see the Apple logo. So that Apple logo would be the trademark, but this would be protected as the industrial design. And then how it works, the internal workings would be protected by a patent. So that's how it works in practice. And similarly with a phone, I'm kind of ashamed to show you my phone, so I'll take it out of the case because that's a little, you know, busted. But the phone now, you again would have the logo, which is a trademark, the design, how it looks, the name iPhone, that's going to be a trademark. You have the haptics and the different sounds it makes and so on. Those will be registered as trademarks. You have the technology inside. Those are, that's patents. You have how the, you know, when the apps and so on it and how those apps look, and those are all going to be registered as well by design, industrial design. So these rights are heavily used, at least internationally, because we in the Caribbean don't really, I don't think we've yet understood how to use these rights to develop brands. But internationally, they're very heavily used, very valuable. I'm going to come around to copyright, but let's go. You also have something called the geographical indication. It's similar to a trademark, but here you're protecting the product because of where it comes from. And an easy example is say Scotch whiskey. So for whiskey to be called Scotch whiskey, it has to be made in Scotland according to certain standards. Similarly with Parmesan cheese. The Americans don't subscribe to the system, so you'll see them using names without any regard for geographical indications. But in Europe, to call a cheese Parmesan, it has to be coming from the Parmigiano region of Italy. Similarly, to be properly called Champagne, it has to be a sparkling wine specifically from the Champagne region of France. To be called Cognac, you have to come from the Cognac region of France, and so on and so forth. Examples in the Caribbean would be Jamaica jerk, Demerara sugar. I think now there's Demerara rum. In theory, West Indies, Sea Island cotton should be one. But those are some examples of what would be protected as a geographical indication. New plant varieties. This is going to become more relevant in the region for the territories that are looking at cannabis. This is where you're looking at what it says, the development of new plant varieties, new strains. So beyond cannabis, I know everybody thinks, you know, we're going to be billionaires out of cannabis, but beyond cannabis, it would be interesting for the region for our horticultural sector, for example, and work done to develop new varieties. So those are protected, not as patents, but specifically as new plant varieties. And then you have the layout of integrated circuits, which I never really talk about. But essentially, you can have protection for how integrated, how they're designed. And it's a very, very specific right, really not used in the region. So that is a really quick tour of key intellectual property rights. And we'll, of course, look at copyright specifically. You have some rights that are analogous, similar, that are not strictly speaking intellectual property rights, but things like know-how and trade secrets, these are also used alongside intellectual property rights. So I'll explain trade secrets, for example. Recipes and formulae are really difficult to protect. When you apply for a patent, the trade-off is the government will grant you exclusivity for up to 20 years to allow you to basically commercialize and
but kids gonna be next.
all right, please make sure you're muted. In exchange for giving you that exclusivity, which also usually means you can charge what you want to charge, and you see it a lot in the pharmaceutical industry, there's a trade-off. That trade-off is society has to benefit from the knowledge and creativity of people. So you can't protect rights forever. So normally you would have protection for a limited period of time, but specifically with patents, once you apply for a patent, you have to disclose the invention. So sometimes rather than go that route, companies will say, I would rather try and keep it a secret. And of course, you would know this from, for example, KFC or Angostura bitters, these Listerine. All of these are formulae that are kept a secret. And they deliberately chose that strategy rather than to make it public knowledge, because after 20 years, it meant that competitors could use the same formula and come onto the market. So to avoid that, sometimes people will go the route of secrecy. Any questions so far? All right, now I'll start to look at copyright in detail. So copyright is one of the key forms of intellectual property rights, but it is used to protect literary and artistic works. There's another category, which is databases. So it really protects literary, artistic, and artistic works and databases. I'm not going to talk about databases. We're going to stick to the primary categories of literary and artistic works. So to benefit from copyright protection, your work has to fit in one of those categories. And photography is treated as an artistic work. So we're talking about books, music, painting, sculpture, architectural drawings, software is also protected primarily by copyright, sculptures, films, song recordings, etc. So quite a number of works are protected by copyright. But unlike the other forms that I just went through with you, the difference of copyright is, one of the differences is that there's no registration process, or rather, it's not a requirement for protection. There are registration systems, and the best known would be the US Library of Congress, where you can register your copyright. But registration is not a requirement for the subsistence of copyright. You don't need to register copyright to have protection.
Excuse me, I don't see photography as a thing here in this copyright.
I just didn't list it, sorry, but
Oh, okay.
I could include it.
All right,
Photography is an artistic work. So if you are told you have to register copyright for protection, that is against international treaties. That cannot be a requirement. When you register copyright, usually it's a question of trying to ensure some level of proof of ownership. And this is why you would hear people say, well, you know, you should register, mail a copy to yourself of the work. Why? Because if you don't register it in a database somewhere, at least you have some level of proof, because when you get that letter coming through the registered mail system, it's going to be stamped and dated officially by the post office, which will be recognized in the court. You can't break the seal, and the copies of the work inside should be dated and so on. You're also advised to keep, in your case, it would be copies of negatives, but for other, like people who do drawings or books or whatever, you also keep copies of your draft work and anything that can be used to prove this is my work and it existed as of X date. And the burden is on the other party to prove that they had the work before. So that usually is a little uncomfortable for people. But the rationale really came from a background where, you know, a lot of people have creative works. And if you made it necessary for them to go through a formality each and every time, it will become really onerous. So as a result, you have this system of no formalities required for protection. And I'm going to come back to that. Now in Barbados, you get protection. So from the time you create the work, as long as it meets the requirements for copyright protection, you have protection until you die, plus 50 calendar years. So that as a piece of property, it becomes part of your estate and your successors can benefit from the ownership of the work. Compared with the other forms of intellectual property, this is one of the longest. The other is trademarks, because you can actually own a trademark indefinitely once you keep paying the renewal fees. But with copyright here, it's life plus 50 years. In many countries now, it's life plus 70 years, and in some countries, it's even longer. Right. So I told you from the time the image is created, it has to be original. So to benefit from copyright protection, your work has to either be a literary or artistic work or a database. It has to fit in one of those categories. And it has to be original. We'll talk about what it means to be original. And it doesn't have to meet any artistic standard. It doesn't have to be a good work. It just needs to, like I said, be in one of the categories and be original. So even if all of us think a piece of work is awful, as long as it meets those requirements, it will benefit from copyright protection. And this is where I want to discuss this idea of exclusivity. So let's give an example of a book or a story. So I decide I'm writing a story about, I don't know, a love story about a man and a woman in Barbados. That's the general, very broad concept. Of course, a million other people could have that same broad concept. It's how I write it, how I express the story that will make it possibly original. Now, it is entirely possible that I sit here in my office, I write this story and someone is sitting in their office in St. Lucie and they write something that's really similar. They've never seen my work, I've never seen theirs, but they're very close. And in that situation, both works will benefit from copyright protection. So this is why I said it can be considered a little weaker than, say, a patent, because with a patent, if I sit in my office in Christchurch and invent something, and you sit in your office in St. Lucie and invent something very similar, then it's a question of who registers first. It doesn't matter that there was no copying or anything like that. It's simply a question, first come, first served. And then you can block anyone else who comes close to what you have. With copyright, you would have to prove there was some copying. So that's the, I don't want to say the weakness of copyright, but it's a reality. The exclusivity is not as strong. So yes, Dr. Mon, photos are, you're going to be looking at copyright for their protection. They're treated as artistic work. So they said there's no registration, but generally for works, not just photos, but for works, literary, musical, dramatic, they have to be recorded in some form. So to benefit from copyright, you would have to have the image, or if it's a literary work, have it written down in some form, but you have to record it. This is not in every country, this requirement. It's not a worldwide requirement, but in many countries, it has to be recorded in some form.
Excuse me.
Yes.
You talked earlier about mailing an image which is sealed and registered to yourself.
Yes.
How does that? Does the digital world have any difference?
Yeah, I the question, and I haven't heard a definitive response. For where the example is given, can you send an email copy to yourself? Or, you know, MP3 or what have you. My assumption is yes, but I've heard the question raised in different forums, and I haven't heard a definitive response. But I would think you can. What I will do though is, what I had planned to do is when we go into the online session next week, look at ways of signing and just, you know, verification systems that are being developed specifically for the digital environment. So it's something we'll come back to next week, but the mailing it to yourself, the question of if you mail a copy to yourself, if that suffices, I think the reason there's no definitive answer is that it hasn't been a court matter. When there's a case and there's a decision, I guess then they'll have some clarity, but it's not, there's no definitive response.
Hello, I have a question. I recently heard with Instagram that we have no actual any right to copyright expectations. Can they violate that actual international right?
From what I understand with some of the platforms, I have to look at the terms of use for Instagram. 1 second. But for some of the platforms, in fact, in their terms of use, once you you know, set up an account and you agree to their terms of use, there are certain stipulations they will have. And I can't remember if it's Facebook, Instagram, but some of them require that you actually give them the right to use with your images or your copyright protected material. So it's not, it's a tricky answer. It's not that they are necessarily violating your rights. It's a question of being aware of what you are agreeing to when you go onto the platform.
Two things. Let us say that when you join up, say Facebook, that they have the right to use your images.
Mm-hmm.
Does that say in the same breath that you lose the right to use your image?
No.
Okay.
I can't remember how it's phrased, but basically it's like you give them a free license to use or non-exclusive license to use.
The other question was on something I said earlier. We're talking about originality.
Mm-hmm.
And is the originality the subject or the interpretation of the subject? If I take a picture of the public buildings, millions of people take it.
It's the interpretation of it.
Right, okay.
Yeah. So I've made a note, and what I'll do is I'll pull, so since Instagram is really based on visual images, I'll pull their terms of use so we can go through it next week. All right, so
I have a question.
Yeah.
My name is Curtis. In terms of, we're talking about emailing a photograph to yourself, but each photograph when it's taken, it has metadata contained in it. Does that metadata serve as any kind of legal proof that you did the work at a specific time, or that doesn't work in court? You know?
It is used as a form of verification. And in fact, what I want to talk about next week is there are copyright organizations that represent the rights of photographers, and they've been developing different systems, making use of metadata to establish databases to allow for the better tracking and monitoring of the works online. So it's something I will go into a bit next week. The use of metadata and so on. All right.
Question in terms of, like, for instance, if you decided you wanted to do a fashion shoot and you decided you want to put a moth on your face over your eyes.
You want to put a moth?
Yeah, a moth.
Okay.
Creatively, you decide you want to put a moth on the model's face, and you then do a shoot with that moth on a particular part of the face, and then someone else does a shoot that has the moth the same place on the model. Is that an infringement of copyright, or is it just?
Well, I think you would have a good case there. First of all, you'd be able to question whether it's an original work, and secondly, yes, whether it's a copy of your work. Just because using this example of a moth is something different or unusual. It would be different. It would be different if you were talking about something fairly basic, like, wearing a scarf on your head or something. But where it is something that is undeniably an original concept, then it is an easier case to argue in terms of infringement.
Recording in progress.
But you do know that
if you do something very unusual, yes, it becomes easier to make that argument. If you're doing something that's fairly standard or basic in the field, then chances are, it'd be harder to prove that it was a copy or an infringement.
Okay.
So the onus is therefore on the person creating it.
Sorry. I need to control this a bit. So Victor, and then I saw Dr. Mon.
Thank you.
Adi?
I was asking if therefore the onus is on the creator to prove that his work is original.
It depends on the territory. In some countries, yes. In some countries, the burden is reversed. It's in the other direction.
Two questions. One is, you do a work in photography, and then somebody paints something very, very similar, basically copying your work.
We will definitely look at that specifically. Yeah.
The second thing is that in more than one case, I have taken a picture, and somebody comes, like say a tree trunk. Somebody comes 7 years later, never seen mine, and took almost identical. What happened? Who has copyright?
Yeah, both of you will probably have copyright. That's the example I was given. I had given earlier.
Yeah.
Where there was no copying, no person maybe never saw your work or anything. They just happened to take a very similar image. It happens, and they could benefit from copyright protection in their image as well.
Barbados is so small that if you're walking along a narrow track, and you come to a place where there's a beautiful image and you take the best, in your opinion, composition, somebody else might come up with the identical composition and not even know that you took the picture before.
Well, it's possible. So I guess it's for you to figure out how, if you want to, for example, commercialize the work, I suppose the best thing I can tell you is try to be innovative in terms of, you know, how you might want to manipulate the work and so on to you know, add a higher level of originality to it. That's the best I can tell you. But the fact is, if someone does something very, very similar independently, they will benefit as well from copyright. We had, I think, Victor, there was an Adi as well. So Victor and then Adi.
My question was answered already. Thank you.
Okay, there's an Adi. Okay. All right, so copyright is a bundle of rights. So when you hear people saying about my copyright, they're talking about a bunch of rights that come under the heading of copyright. And these are generally grouped into two categories. You have the economic rights, which are exclusive and include reproduction or the right to copy. So you own the copyright, you have the right to authorize others to make copies. And copying is, you can have a literal copy, like a photocopy. You can have copying when there's a three-dimensional work and you take a photo of it and, you know, it becomes a two-dimensional work. If the three-dimensional work was a piece of sculpture that is in itself protected by copyright, you can then find that you have infringed the rights of the sculpture by making a copy in two-dimensional form. So copying in copyright is not just literal copying. You have the exclusive right to authorize distribution or the issuing of copies to the public. Importantly, the right of adaptation, which goes back to the question Dr. Mong was asking, and we'll look at an example there. And there are other economic rights, but I didn't mention them because they are not as relevant for photography as, say, for music and film. But there are other economic rights, including the right of public recitation, right of public performance, the right of broadcast. There are various other rights.
Two things again.
Yes.
If I've taken many pictures of Nelson, and
Mhm.
all of them from some creative thing. And if I took the entire image of Nelson, would that be infringing on somebody else's copyright?
No, because remember, the life of copyright is only, at least in Barbados, up to 50 years after the death of the author.
Okay. The other question would be, if say somebody was within the copyright period for a statue, and I took a picture of a scenery, and in one small part of that scenery had the statue, would it be infringing on that copyright of the statue, or
Right. So there's I actually have that as something to talk about, which is fair dealing, fair use, fair dealing, where there's what you call incidental copying. So we'll get to that. But yeah, if it's just incidental to the work, there are some exceptions under the law. You have what are known as moral rights. Mainly the right to be named as the author. So when you create the work, you are the author. And if you can, as remember we said these are property rights, so you can sell or transfer your copyright. And that speaks to selling or transferring the economic rights. Now, I don't know, it happens really with photography, but in a field like music, you can sell each of those economic rights, or you can transfer each of those economic rights to a different person. So you might find for this right, you need to go here, for that right, you need to go there, etc. But with the moral rights, the rights to be named as the author, the right to object to any use that could bring dishonor or disrepute to you as the author, those rights cannot be sold or transferred. Those rights remain with the author, except they can be waived in writing. And you need to be really careful when you're signing contracts if they speak to the waiver of your moral rights. If you do not want to have, so let's say you're, I don't know, you say you're a Christian or you just have certain principles. You may have a nice work. It may be of a lady or a man or whatever, and you want to ensure it's not manipulated in a way that may make it obscene. Even if you sell the rights, the copyright in the photo, you should be clear that you're not waiving your moral rights because you want to control any editing or any further use of the work or manipulation of the work that could bring you into disrepute or lower, be seen, for example, as lowering the standard of your work, the standard for which you're known. So you have to be careful when it comes to that issue. If you don't mind, you can waive it as part of the deal. But if you know you have certain requirements, always check for any requirements that you waive your moral rights. An important right, of course, is always to be the right to be named as the author or as the photographer. So that's where moral rights can be really important, and you need to understand that they're separate and distinct from any economic rights you may have in your work.
I'm sorry, quick question. This is more from the perspective of a model. Would a model have moral rights in terms of being captured? Would she be considered as she's put on makeup, she's got on the clothes and whatnot? Would she be considered
No, but I'm going to touch on the issue of release fund.
Okay, and second question, which was alluded to with respect to the statue. What about taking photos at a particular property? Would you need, would the person be able to object if their house is in the photo, a wall on their house or whatever?
We're going to talk about that as well.
Okay.
Question, Erica.
Yeah.
2 questions here. What if I did a painting of a photograph and I replicate it just as the photograph? Would that be seen as a copyright as well?
Yeah, because the author of the photo has certain exclusive rights, including the right to authorize the copying. Remember I said in copyright, copying is not always a literal copy. So you can do a 3-dimensional copy of a 2-dimensional work or a 2-dimensional copy of a 2-dimensional work. So as long as it's protected by copyright, they would need your permission to make that copy.
And the other question is, I see your signature is also an issue as
It's
a
also,
intellectual property with photographers and painters and artists, your signature and the image. What if somebody use your signature on your image and place it on another image? Would that be seen as copyright as well?
I think in that case, we might be more into, that's a moral rights issue. So signatures are usually, in terms of IP protection, they're normally protected as trademarks. If someone takes your signature and places it on their work, that is actually just plain fraud. So you don't have to even look at IP law, that's just straight up fraud. But it's also going to touch on the right of you to be, just as there's a right to be named as author, you have a right not to be not named as author. Because if you think about it, if your name is attached, if you are recognized as the author of a work that can also bring you into disrepute, it has the same effect. So it would speak to moral rights infringement, but like I said, it's just basic fraud. But in terms of IP protection, signatures are generally, unless, I can't think of an example with copyright for a signature, but signatures, normally it's going to be trademark protection. So remember I said there's some instances of trademark law that might be of interest to photographers or artists generally. Very well-known artists or artists whose signatures are recognizable, so that they serve as indicators of source. And I don't, let me think of how to say that in a less technical way. There's some artists whose signature is so well known that from the time you see it, you know whose it is. Those are definitely protected, going to be protected as trademarks. However, you do not have to be famous to have your signature protected as a trademark if you wanted to. So if you are a visual artist with some, you can also look to ensure that your signature is protected as a trademark, which would just reinforce protection against copying. But in most territories, you aren't going to get copyright protection for a signature.
Thank you.
All right. All right, so when I was thinking of what to cover, I figured we need to talk a little bit about privacy, and this will go into the question with taking photos of, property and so on. So there is, in the past few years, there was a case that established a right of privacy. Does exist in our Constitution, but we're like the UK, we do not have a specific statutory right in your image. So when you hear people talking about image rights, we don't actually have image rights in Barbados. What you do have to pay attention to, though, would be, and I have them listed here, when you're taking photos, you have to consider things like protection of minors, children, issues of national security. Sorry, I need to plug in these. You have to look at ethical issues. So there may not be rights in, there may not be image rights as such, but where you do take photos and so on for commercial activity, you could still have issues found, you know, in other torts or something, but there are no image rights as such, but you should still pay attention because you can have issues arising under other legislation.
Question,
Yes.
question or clarification. Now,
Mhm.
let us say I take a picture of a building,
Mhm.
and that building, just take the building alone. My understanding is I have the right to take the building, but I may not have the right to use it for financial gain unless I get permission from the owner. Is that correct? Or I can still use it?
I don't know that with, let me see where I have it. With images, with buildings. Please tell me I included it. Oh, fair dealing. All right, I'll get to images somewhere.
The other question was,
Here, like here, if it's in a public place, you can take the photo.
okay, the other question is, if I take a picture, well, this would apply, in my case, to chattel houses. I take a picture of a chattel house, and 3 years later, that chattel house is demolished. Do I have full rights of so that the imagery or the people who own the house originally still have rights?
No. You want, in Barbados, you have a right to take a picture of a building in a public space.
Right, okay.
It becomes tricky if, like I said, it's a sculpture, for example, that is copyright protected.
Right, okay.
Right, but I further on the presentation is section 73. You once is in a public place, and similarly with people in a public, you know, an event, a public event or whatever. We don't have anything that explicitly prevents you from taking their photos. What can get tricky is with celebrities, for example, who may have trademarked their image or certain looks of their image, you know, profiles, for example. It can get tricky, but, you know, we are not California with these very clear, very specific image rights. As I said, though, outside of copyright law, there may be issues or provisions of other legislation that will come into play. So my advice is, personally, I think it's just decent that you, especially images of people, you usually just ask permission or let them know that I'm taking your photo and give them the choice. At an event, say like crop over, you know, Kadooment Day or whatever, the fact is that kind of very public event. It's free for all, really, unless, and I don't know that the NCF has any, I don't know if they have any specific restrictions as producer of the event, but I just gave a street fair or street carnival as an example where, you know, you can take photos. The one-off vendor sitting there, I think you know, the thing is to at least ask for permission. But strictly speaking, you don't really have to in Barbados ask for permission anyway, but it's just.
Is there any restriction for us taking government property or government buildings?
Only where it becomes an issue of national security.
Okay.
Yeah, but we need to be careful because I know people talk a lot about image rights. but we really don't have any specific legislation speaking to image rights. So just like the UK. So what happens is you normally look to this issue of privacy. Again, we don't have, well, let me bite my tongue there. Because I think there was a case 2 years ago that established, I don't know if it was at the CCJ or I don't know which court. They did acknowledge there's some right of privacy in our constitution, but it's not that we have, you know, some legislation that speaks to this specifically.
Right. Question, you said public building. What about private buildings?
Yes,
What
as
would
long,
constitute private?
no, as long as they're in the public. So, you know, you're walking the street and see a building.
Okay.
Yeah.
So there are no private buildings then?
Yeah, I don't know what private building is.
Unless you go into a gated community, perhaps.
Yeah, well, once you're within the community, fine, but it's not that, or unless there's some contract that you sign. So you go into, I don't know, some sort of private resident, gated community area, and you know, one of the conditions for you being in there is that you take no photos. Then it's a contractual provision.
Sorry, are you a lawyer?
I have a law degree. I don't practice. And I can tell you a bit about my qualifications. So I have an undergraduate degree in management and an undergraduate degree in law. I have a master's degree in international business. I have one in intellectual property law. I have one in international sports law and management. I have a doctorate in, my research was on copyright management in the digital environment. And I'm now wrapping up. I just did another master's in intellectual property law and management, but it really looked at the strategic use of intellectual property. So business strategy and IP. So that's my background. I've been in the field since the year of 2000. So, in terms of this right of privacy, in our legislation, there's a specific provision, I didn't say the section, where when someone commissions a work for their private use, they do have some rights, some privacy rights explicitly granted in our copyright legislation, where you cannot issue copies or exhibit it in the public or show it in the public or have it included in a broadcast production or cable program for their permission. So the Copyright Act itself provides for some specific situations where a right to privacy has to be respected. So when we talk, I think no, and we really need to move it under. I didn't have many slides, but I thought I would get through faster. But I definitely want to get to commission works, if nothing else, tonight. And maybe we may have to do this for 3 weeks to cover everything. Someone asked earlier, so release forms. So you call them model release, but it's really where you're taking a photo of someone. And as I keep saying, it's not a legal requirement, but it's just serves as like, confirmation of consent. So you see the fruit vendor, and it's a nice shot or whatever, you ask their permission, you just have them sign off on the release. So a model release could be an actual like fashion model, but basically we're taking photos of persons, you just have a release form that you provide them. And this is something I recommend. It doesn't have to be anything highly technical. It could be just a few lines saying, yes, I've agreed to have my photo taken. I think it's also ethical if the intention is to commercialize the photo in whatever way that you let them know. I don't necessarily think you should put that possibility out there unless you really want to, because then there is a possibility where they say, well, I want to share benefits, but something that's broadly stated, they've given you permission. That's enough, because then it doesn't explicitly bring anything of commercial or not commercial use.
In this thing that is on the computer now,
Mhm.
it is not a requirement by law.
No.
But if you do have it, is it respected by law?
Once it is dated and signed, yes. It's like a consent form, and these are used. You have release forms used for photography. You have them used for performances and so on. So it's like a little terms of use type agreement. That's not to say you take the photo, you commercialize it, it becomes really, a huge commercial hit or, a success. That's not to say that the person may not come back and say, well, when I gave you permission, it could be challenged. It's not to say it can't be, because they may say it was not, their expectation and so on and so forth. So whilst it can show, yes, you had consent, there is a possibility that you take this image, it becomes worldwide, a worldwide phenomenon. I am not saying that it would not be challenged and that there would not be expectation.
Yes, on the issue of minors, is like, for instance, you may take photos of a school event, a football match or cricket match or whatever. That's public. So would that then be acceptable?
My strongest advice to you is anything with minors, seek consent, seek clear consent.
Okay, and would this minors be up to 18, or would 16-year-old be still considered minor in that situation?
Well,
I think I'd heard that. So I think 16 plus was.
No.
You could get consent.
If you want under 18,
Okay.
seek parental consent. So I don't know how it works. If there's school sports, I assume that the Ministry of Education or the principal or someone has to still give you authority to come and take the photo.
I think for some events, what happened, I'm a teacher, so what happened, I think we had sent out forms to the parents from the beginning of the term, asking permission for the likelihood that certain things might be taken at the school. I think one situation occurred where a particular child hadn't given consent, so we then had to because the lady came from the Sports Council to do a video for the online teaching thing.
Mhm.
And so we had to pull out children that weren't, the parents didn't consent, but otherwise, okay.
The other issue is that if you are doing a model release and it involves minors, yeah, the parents have to consent, which means that they have to sign. But
Mhm.
is it wise to get the child to sign also, or just the parent?
The child really has no legal standing. The important thing is the parent. Adi, I assume you pronounce it Adi, has their hand raised. Or had it
Yes,
raised.
AD ready. This is a situation with a property owned by an expat. The property manager allowed me to come on the property. The owner being in Germany. I took some lovely photographs.
Mhm.
Do I have the copyrights to those photographs? And is there any legal ramifications of me publishing photographs on that private property?
Right, so I don't know all the circumstances, but my first question would be, why were you taking the photos? I mean, were you asked to take the photos?
No, I wasn't asked to take the photos.
You just wanted to take
I found some interesting aspects on the property itself and thought that it would be nice to photograph it, like the pool and that kind of stuff.
All right, so under our act, section 73, give me a second, I'll put it up. Do I have, stop share. You can take photos of buildings in public. My concern, and I don't know all the facts, so I don't want to be very definitive. Sorry, if I had it, yeah, let me put it up. One of my first concerns would be what is captured in the photo. Meaning that it cannot include anything that is otherwise protected and for which permission would be needed. So, insofar as it doesn't include anything else that's protected by some form of IP, including trademarks, you shouldn't have an issue. At any rate, you would be the author, owner of copyright in the photo. The question then becomes, are you able to use the photo and how you're able to use it?
The other question would be, did he take the images of the property on inside the limits of the property? So was he on the properties
as a trespasser or not?
or was he outside the property in a public place taking it?
But if the property manager give,
I was actually on the property. The interesting thing would be if the designer of the pool, the person who had designed the pool, had any rights to that pool as being unique to Barbados, you know.
The other question is if you use one of these drones, you can't prove if you were outside the property or over the property or what.
Yeah, but there's always the question. Yeah, okay. There's always going to be the question of trespass and whether you trespassed or not. My assumption, and I feel I don't really want to speak too much on it without all the facts, but my assumption is that sorry, I'm just trying to find the act. My assumption is that the property manager would have been duly authorized to give you permission to be on it. In terms of the pool, the drawing of the pool would be protected by copyright. But my understanding of our legislation, and I don't know why it's given me, sorry, you just need to be a little patient with me. I had it open before, and now it's closed. My understanding of Section 73 of the Act is that barring other considerations such as trespass, the issue of trespass, you should be okay.
So some while ago,
Yeah.
the Photographic Society was trying to get permission to take pictures at the Harrison's Cave, and but they didn't allow it at that time, saying that the problem was that the architect who designed inside was claiming copyright. The owners, the government as owners, at that time they were saying their copyright, and there was a third, and there were three different entities that were claiming copyright of the
All right.
place.
In the case of the government, though, the government will have certain rights that would extend beyond most private citizens. So I don't know, for example, there should be legislation that speaks to the Harrison's Cave specifically. I don't know that legislation, what it provides for. I can't really speak to that. I don't know if their claim is properly based in copyright or if they actually have restrictions under the Caves of Barbados legislation or whatever it's called.
Yeah, Erica, I think their concern was largely to do with commercial benefits. They were concerned that photographers would take photographs of stalactites, stalagmites, etc., and make money off of it, making postcards and different things like that.
Okay.
A question.
I'm sorry, I'm getting a little antsy because you will have to accept that we aren't going to get through this slides today for sure. All right. I mean, I don't mind, but you just need to understand that.
That's cool.
Well, kind of. I can extend it to 3 sessions.
Yeah, we would like that if possible, rather than cut short, because it's not
right.
well understood. A very interesting topic.
All right, so
Okay.
We can do 3 sessions. The only thing I will need to check is whether I can do the Thursday after the next. So I am committed to next Thursday. But I'll talk with Brandy. I need to look at my schedule. I don't want to spread any other sessions too far apart. But I just need to look at my other commitments to tell you a 3rd date. Let me just, because I was looking for the act for the provision. I'm going to ask that you let me know that, and we come back to this whole issue of, Harrison's Cave and architects' rights and so on. What I can tell you is that the law basically provides if it's in public, you can take the photos. My thinking, and I never looked at the legislation governing, for example, Harrison's Cave, but my thinking is that they may have specific requirements. It would be different that would be different from, say, just a normal residence. And then you complicate the issue by bringing things where you have to look at privacy. And then I would have to look and see what goes on with drones, you know, how trespass is treated with drones. So you're asking me questions that I would really need to know, go and research on, because I honestly never thought about the issue of drones and trespass. And
Well, with regards to drones, I suspect that the argument would be more a matter of airspace. There's a certain amount of airspace over each home, each residence, and so on, where you can expect a certain amount of privacy. At least that is in the American and Canadian laws.
yeah, but I don't know if it's here. And I have an issue where I don't want to assume because it exists in other territories that there's an assumption it automatically applies here, because in fact, there are usually a lot of differences. So I would have to really either research or ask a question.
Well, I suspect that it would be similar, because I think we took our drone laws out of Canada. But again, I will defer to what you said. It'd be better to find out what the actual act is with regards to this. There was a question, but I forgot. So I'll come back to it.
All right, you can come back. All I wanted to show you quickly, whilst we can deal with questions, is what I want to go through. I want to definitely look at the issue of ownership. And I would like to discuss the issue as it relates to people who work for newspapers, for example, because I know often there are some challenges there. And so I want to be able to go through that with you. I want to also look at the issue of commissioned works beyond newspapers. So things like where people do wedding photography and so on, the ownership of the work. And then I also had the issue of fair dealing. And I think it was Dr. Mon, I can't remember the right, incidental inclusion. So fair dealing, and it comes up, for example, you take a photo and it's used, say, in a newspaper, but then there's a further use made of it, and things like using for education and so on, and examinations, and use in court. So I wanted to be able to discuss those, and then I think it was Dr. Mon, and this is the example I would like to go through. So this is a fairly well-known case where you had a poster made off of a photo. And it happened, this was a case in the US. And well, I don't want to anticipate the complete discussion, but I want to be able to discuss this with you. Right, so architectural works protected by copyright, but permitted to photograph a building if it's located in a public place or visible from a public place. So those were the issues. Let me go back. And then I mentioned taking a photo of a trademark or something with a trademark, and the limitations there. So I thought these were issues for 2 hours, but I was wrong. But these are the issues outstanding from today's presentation. So I will schedule another date, and you have to decide. You can discuss it amongst yourself and decide. So what I want you to do was to discuss these first and then go into the online environment. And the reason I wanted to do it in that order is because these are really the basic rules. And then so these are the basic rules in the traditional environment. A lot of them apply even when you go into the online environment. So I just wanted to make these clear and then move on to the online environment. We can next week move on to online and then come back to these issues, or we can deal with these and push back the online. That choice will be up to you. When I speak to the online issues, I also wanted to touch a little on the collective management of rights and photos. I don't know if there's an interest in it. I don't even know if it's feasible for Barbados or maybe on a regional level, but I just wanted to let you understand that there is that possibility. And I know that if there's enough of an interest, it wouldn't just be photographers, but the visual arts. I suspect if there's enough interest, you could get support. But I think that's somewhere down the line. But I just wanted you to at least be aware of what's done in that, in terms of that activity. So those are the things to be discussed. I can take some more questions now, or I could start with a few minutes left and start looking at ownership. So the choice is yours. So are there more questions, or do you want me to at least start on the ownership of copyright?
Start on the ownership of copyright.
Okay.
I second that.
Okay. So the author is the first owner of copyright. So you take the photo, you are generally the author, the first owner of the right. You will always be the author, but not necessarily the copyright holder or owner. As we said earlier, you can always give or transfer your rights to others, and then they become the copyright holder. You remain the author, and remember what we said about the moral right. So unless you waive your moral rights, you have the right to always be recognized as the author, but you don't own the copyright if you've transferred or gifted the rights. In terms of employment, in the employment situation, the employer is the first owner of the copyright. You're still the author, but the employer. So you have to be an employee, and it has to be taken in the course of employment. So if you were at the bank as a teller, you take a photo that the bank, decides to use. You haven't done that under your job description in the course of your employment, and it should be subject to specific terms and conditions. But if you're employed as a photographer, you're expected to take photographs. Your job description, your contract should speak to it. The employer is the first owner of the copyright. You are the author. So you need to distinguish employment from a freelance situation. And this is where, at least in my experience, when I get questions, it's where I get probably the majority of the questions from people who take photos for newspapers, for example, in a freelance situation. First of all, you should have a contract. that clearly states the terms and conditions you agree to. To have an understanding as to the scope of what you have agreed with whoever you're taking the photo for. And you need to consider things like editing the work, because obviously you also still have your moral rights. And you need to ensure that the work lives up to your standards. You need to be clear about the use, and important in our environment, well, nowadays is the media that would be used on. So if I'm the newspaper, for example, I'm going to have an agreement that says I have the right to edit. I have the right to use it as many times. I have the right to use it in all media, so online, traditional media, etc. And in fact, I would really ideally have a contract that says all your copyright transfers to me. You will retain the right to be named as the author, but you will waive all other moral rights. If I am working for the newspaper, that's how I would set up the agreement. Obviously, you as a photographer might want to have a different understanding, but the point is you have copyright, but the copyright and how it's exploited will be shaped by the contract and how the contract speaks to the treatment of these intellectual property rights. You also have a situation where you as a photographer might set up a company. So you're in it professionally, you set up a company, and you, for accounting and tax purposes, are an employee of the company. Now be careful, because then you're employed by the company as a photographer, which means the rights are now owned by the company, not you, unless your contract with the company you've set up says otherwise. The company, as with any other employer, will own the rights in the copyright in the photography you take as an employee. And
before you go on, if you're the sole owner of the company, how does that work?
But it's a company set up as a separate legal entity. So the rights are owned by that legal entity. And you need to be careful. It happens a lot with celebrities, especially. You set up a company, transfer all the rights to the company, you think you're the sole owner, then the company is sold, etc., and the rights are sold or transferred. If it goes into receivership, whatever, you could lose the assets. And remember, these are assets. It's just they're intangibles, but these are assets. So then they're assets of the company. So I don't know how many of you may have that level of sophistication in your setup, but I just thought I would mention it. That where you're an employee, even if it's of your own company, if you're employed as a photographer, unless there's a contract, I remember the law provides for certain things, but these can be varied by contract. So unless there's a contract that says otherwise, the company or the employer will own the rights in the photography, in the photos. And I'll do one more.
Sorry, so if I decided to have a business name
then is that technically a company? Or?
No. A business name is not the same as a company. So when I speak of a company, I'm talking about an incorporated entity that is a legal person. It's a legally recognized entity in and of itself. A business name where you pay, I think, the 130 with Kaipo, it's just giving you rights to a name. That's it. And you trade under that name. But it's not a separate legal entity. All right. I don't want to go into commission works. I was thinking of starting there, but when I start with commission works, I will need to continue. I may be wrong, but I suspect this is where I'm going to get a lot of questions. So I will definitely not start on commission works. No, it's also 8 o'clock and I really need to wrap up. I actually have something else after this to do. So I will wrap up here. As promised, I will make the recording available. You should discuss with Bradley how you want to proceed next week. I'm open. I have noted some of the questions, so I'll make sure, including the Instagram terms of use. I'm not going to discuss that until we do online, whether we do online next week or later. But I will have noted it and I will pull their terms of use and we can go through those. If there are other questions coming out of tonight's session, again, well, I will just put my email. You can always talk to Bradley since he's been my contact. But I'll give you my email and you can contact me directly. But if there are other, no, Bradley, this is not the email address you have. This is my private email here, but that's my email address.
Okay, no problem. I have both actually.
Okay, so if you have any specific questions from tonight's session, I don't want to speed ahead, but from tonight's session, you can send me. I can answer you directly. I can also, depending on the question, just deal with it in the following session. But I've noted the different questions and so on, so I will address all or try to. But for sure, it's going to be more than 2 sessions. So tell Bradley how you want to organize that. All right, and I will go with the flow. But that's all for now. So thank you very much.
Thank you too.
Thank you.
And thanks for everybody for coming.
Thank you.
I'm sorry if I sound a little rude. I had a really long day.
Your time is valuable, so I understand.
Yeah, I don't mind. I don't mind.
It's greatly appreciated.
I'm here just thinking I need to really look at how I organize this place so I don't underestimate the time required. But it would really help once you decide if you want to do online next week or if you want to continue with this, and let's look at least start with commission work and situations where people can use your works without infringing your rights, which is called fair dealing or fair use. Just as I said, let me know, and any questions you are aware of for the particular subject matter that you want to send in advance, and I would prepare so that I can, address them. That would also help. But feel free to contact me. I really don't. I like engaging, so feel free to contact me with any questions and so on. I am also going to see if it is possible to have someone from one of the international organizations who manage these rights collectively speak to you. I don't want to promise it, but it is something I was saying would do to at least let you have an understanding of how rights are managed collectively, if you're interested in understanding that a bit more. So these are things we can discuss as we go ahead, but I want to say it was a pleasure. And I would like you to be able to, for those of you who are doing this as only a hobby, to make the most out of it, but for those of you who are doing it professionally, especially under the current circumstances, I would like to see you, be able to make the most out of it as possible. So I'm willing to help, but right now I have to say good night. So take care, everyone. It was nice engaging.
Thanks.
Good night.
Thank you, everyone. And everybody have a good night.